Okay, thank you everyone for all coming today for the week 3, how to apply for orders in the Provincial Court of BC. We are grateful tonight to have our presenter. We have Catherine Penton, and today's session is October 22nd, 2024. So I'm just going to go over some of our beginning slides. We would like to take this time to acknowledge that we are on the traditional, ancestral, and unceded territory of the Musqueam, Squamish, and Tsleil-Waututh nations. A brief overview just about AC Friends of Court. We are a nonprofit organization that began in 2011. We first with our legal forms workshops. We are held in different areas now with Vancouver, Surrey, Richmond. We have helped workshops for British Columbians access affordable legal help for a variety of areas of law. And this is one of the first of its kind, these programs, to do a family law school. A brief acknowledgement to our generous supporters. We could not have done this program at all without the people that are on the screen. And just an acknowledgement that some of our work is adapted from the resources that were originally developed by the Justice Education Society, the National Self-Represented Litigants Project, and Legal Aid BC. A quick reminder of the differences between legal advice and legal information. So legal advice is answering questions or providing information that is specific and directly linked to someone's legal case, whereas legal information is answering a question or providing information that is more general, so not specific or directly linked to somebody's case. In this course, we do not provide legal advice. We only provide legal information. So just make sure to keep your questions vague and not related to your case in any of the questions that you ask during this course. A quick housekeeping, where we'll be recording all of these sessions and they will be emailed to registrants at the end of the week usually. If you haven't sent in your participation agreement, just make sure to do that. And a reminder to mute and turn off your videos during the entire session. If you have questions, just keep your videos off and instead put them into the chat box. And again, keep your details about your case private. Just admitting a couple people. If you have any questions or concerns, our email address is here. You can send anything to our email and we will try to get back to you as quickly as possible. We ask that everybody respect our speakers, either whether it's ourselves as the moderators, any other volunteers, or the participants or speakers. Week's 3 objectives is going to be going over applying for orders, family matter reply and counter application forms, applying for other orders, the family justice registries, and parenting education program registries. So I'm going to pass it off now to our presenter today.
Hey, thank you. I'm just going to share my screen here before we get started. Okay. Hey. Thank you, Rachel. So as she explained, I'll be going over how to apply for family law matter orders in provincial court. Some of what I say today might touch on some of the other presenters' information that you may have already heard or will hear later. And that's mainly because I want to make sure that when I'm going over the particular orders, that there's at least the base knowledge of it. So now before I get started, I'm currently sitting out in an office in Chilliwack, so I just wanted to acknowledge that I'm on the traditional, ancestral, and unceded territory of the Stolo Coast Salish peoples out here in Chilliwack. So I've included a bio of me. I'm not going to go through it. In general, I currently practice family law. I've been practicing family law since I received my license about 5 years ago. And I exclusively practice in family law. And I've appeared in both provincial court and Supreme Court in various court registries across British Columbia. So the kind of general outline of my presentation today will be going over what types of orders there are. So including kind of a brief explanation as to what each of those orders relate to, what's the difference between interim and final orders, and how to word orders that you're looking for in court. And then I'll go over the different court forms. I'll give a very brief explanation of each, just to give an idea as to what types of orders would fall under those types of forms, and then what's the requirement for each forms. I won't be able to go into all of the forms that are available in family law matters in provincial court, but I will be going over kind of the main application and reply, as those are typically what most people will be using if they're going to provincial court. I'll also go over kind of briefly what kind of documents you might need for it. It will be very general because it is going to be more dependent on what you are asking for, but I'll try to give an idea. I'm also going to go over how to serve because I do find a lot of individuals tend to struggle with what they need to do for service and what kind of options there are if maybe someone's avoiding service. I'm going to go over some general tips, and then I've outlined some additional resources that I think are very helpful for anyone who's not a practicing lawyer, that are free and available, that just simply the public doesn't know about. Because surprisingly, there is a lot of resources out there. They just are hard to find if you don't know where you're looking. Because I personally will sometimes use those same resources as just like a refresher if I haven't worked on something in a while. And then we'll just end with some questions. So with that, what are the types of orders that you can ask for in provincial court? So there are specific types of orders in provincial court compared to Supreme Court. So the ones that you can ask for in provincial court are parenting arrangements, child support, contact with a child, guardianship of a child, spousal support, and then companion animals, also known as pets. There are other types of orders that you can seek, but they are a bit more complicated and tend to not be the typical orders that I see going through provincial court. But other types are foreign child and spousal support orders, adult guardianship, Hague Conventions, which include children who have been wrongfully removed and retained in BC, or child protection, which would be the BC Ministry of Child and Family Development. So with that, what are parenting arrangements? So parenting arrangements can include parental responsibilities and parenting time. I will also go over what those terms mean in general, but essentially you can think of parenting arrangements as custody. In family law, in both the Supreme Court and provincial court, we don't use the term custody anymore when it comes to parenting. Our Family Law Act and the Divorce Act no longer use those terms. They are essentially split up into the parental responsibilities and parenting time. But given that the majority of people in the public still use custody, and quite frankly, lawyers do as well, if you hear the term custody, just think that it's parenting arrangements and vice versa. So now in British Columbia, the only people who can have parental responsibilities and parenting time of a child is somebody who is a guardian of that child. I will go over what a guardian is later, but if you are not a guardian, you cannot get orders about parenting responsibilities or parenting time. So it's really important for you to understand whether there is a chance that the court might disagree that you are a guardian, which could end up having delays in your court matter if you have to essentially start from the beginning. So it is important to understand that. So what are parental responsibilities? So in this slide, it's a lot, but I will summarize it. This is essentially just a direct quote from our Family Law Act under Section 41, which just outlines what is considered a parental responsibility. Essentially, think of it as making decisions that are required for the care of your child. That can be simple decisions, such as who they're going to associate with. Maybe you don't want them to have contact with maybe a certain family member or friends. That would be a decision as a parent that you would make, or decisions like what school are they going to go to? Are they going to go to a private school, public school, French immersion? What medical care do they require? Are they going to get certain vaccines or not? All of that falls under parental responsibilities. So if there's anything regarding a decision about your child, it most likely is just under parental responsibilities. Now, parenting time. Parenting time is just the time that a guardian gets to spend with the child. So what that parenting arrangement looks like depends on the parent's ability to parent, as well as the child's needs, and essentially the family dynamics. Some people's family will have shared parenting, some won't. There is no right or wrong answer to parenting time. And I've outlined some different types of arrangements that you can have. Kind of the typical ones are a week on, week off. For younger children, it's usually, if you're going a shared parenting route, something like a 2-2-3 schedule or a 2-2-5 or a 2-2-5-5 schedule. Other typical ones, if maybe there's one parent who has a more demanding work and is unable to do 1 week on, 1 week off because they can't facilitate like school pickups or drop-offs, they might look at maybe 1 day during the week and then alternating weekends. And so there's no right or wrong answer. Just think of what works best for your family and your children. Now, child support. Sometimes the court will refer to it as maintenance. I do find that they typically use the word maintenance more so for spousal support than child support. But child support is money that's paid from one parent or guardian to another for financial assistance following separation. Now, children are legally entitled to child support from their parents, even if you and your spouse agree none's going to be paid. That doesn't mean anything. It is the child's right. So if you're going into court and you're not going to touch child support, be prepared that the court's going to ask you about it, because they also have a duty to the best interests of the children, and child support is being one of those. Now in BC, child support can be paid until a child is 19 years old. And there's certain circumstances where child support could end before 19 years old, or it could continue after they have turned 19 years old. And those special circumstances vary, but Typically, it is around 19 years old. Now, the amount of child support payable also depends on your particular circumstances. The amount payable doesn't change by the child's age, but it is dependent on what the parenting arrangements look like and what the parents' incomes are. So I have included a link there for if you want to find out how much child support might be payable. And if the link for some reason doesn't work, you can simply just type into Google child support calculator and just look for the one that's from the Canadian government, which is the justice.gc.ca, as that's directly from our government, and that is what the courts would be relying on as well. There you can just put in what province you're in, what the income of the parent who's paying child support is, and how many children there are. Now, unlike child support, spousal support is not an automatic entitlement. In order to obtain spousal support, the person who is seeking the spousal support has to demonstrate to the court that they are entitled to spousal support. And then only after that entitlement is established that the amount of spousal support would be determined. Both entitlement and the amount payable for spousal support is subject to many different factors. So it's not as simple of a calculation compared to child support. I have included a free calculator for spousal support. It is very limited, and I would very much caution relying on it too heavily because it's not a perfect model because there's so many different factors that can apply. But if you're going into a court situation and you don't have the ability to maybe speak to anyone in the legal realm who might have access to a better calculator, this is something that can at least help give you an idea as to what to look for in court, or at least to have a standard if the judge themselves provides some numbers, or even in negotiations. So what is contact with a child? Now, unlike a parenting time, contact with a child can look very similar to parenting time, but the main difference is you're not a guardian. So even if you aren't a guardian of a child, you can still have time with that child. It just wouldn't be referred to as parenting time. Instead, it's contact with a child. Now, typically, contact with a child is more used for grandparents where maybe the grandparent's child is no longer with us and the living parent is refusing their grandchildren to have any sort of relationship with them. The court might grant contact between the grandparents and child. I've rarely seen it for anyone outside of the immediate family, like grandparents, but in general, it is just for anybody who's not a guardian of the child can get orders for contact with the child. The schedules can also look very similar. It's going to be very rare for there to be any sort of contact order, that it would be, say, a week on, week off. Because you don't have the same essentially rights as a guardian would to the child, because a non-guardian can't have parental responsibilities. So you wouldn't want to be in a situation where the child is in your care for a week and you can't make any sort of decisions, like say in a medical emergency. So if you are in a situation where maybe right now you could be a guardian, but you aren't a guardian of the child, you could get orders for contact, which could then change into parenting time later once you are a guardian. So with that, what is a guardian? So generally, biological parents of a child are guardians of that child. But if you were not living at the time of the birth of the child, or you were not involved with the child's care following that birth, you may not be considered a guardian under the Family Law Act. In most cases, as long as you are a biological parent and you were present after the child's birth, you will most likely be found a guardian, and you don't need necessarily a particular order saying you are a guardian unless someone is questioning it. But that is still with caution, as it is still better to make sure that the court finds you as a guardian, which is something I'll go over more in the application as to kind of what you want to fill out there. And the other thing to think of is if you are someone who's been involved in assisted reproduction, unless you have any sort of agreement, there's a chance that you are also not considered a guardian under the Family Law Act. So before applying for any types of orders, you should consider whether there's a chance that you might not be considered a guardian. So if you aren't a guardian, you will want to apply for guardianship while you're also applying for any other orders relating to that child. So you can still apply for orders on parenting time, parenting responsibilities without being a guardian, but you'll also need to apply to be a guardian at the same time, because they won't be able to grant you any of those orders until they find you a guardian. So the last type of order is a companion animal. So companion animals are also known as pets. This is a very new area to our Family Law Act. There has been previous cases kind of around this, but it was never in our legislation. So unfortunately, it doesn't, our Family Law Act doesn't provide a definition of what a companion animal is, but they do outline what's not considered a companion animal. So what's not a companion animal is a guide dog or service dog under the Guide Dog and Service Dog Act, an animal that is kept as part of a business, or an animal that's kept for agricultural purposes. So for those last two, you can think the typical ones are think of like cows, sheep, animals that are part of a farm. And those are typically not companions. So family pets have always been considered property under family law, and they are still considered property even with these changes. But instead, with these new changes, they are essentially treated a bit differently than how you would treat standard property. In standard property cases, your options are usually selling it and splitting the proceeds from it, or one person keeping said property. Or if it's some sort of property that can be physically split, physically splitting it. Obviously with animals, those are not really something that you can do. And then there's the difficulty as to who's going to keep this animal, because typically they also don't have an easily valued amount, because it is more of a emotional, sentimental piece and not a physical piece of property. So this is the only type of property that can be dealt with in provincial court. If you have anything that, say, like a bank account, a piece of land, all of that cannot be dealt with in provincial court. This is the only type of property that can be dealt with in provincial court, are companion animals. So what are final and interim orders? These are most likely terms that you're going to hear when you're going throughout the court process. So when it comes to final orders, well, they are final. They are typically made after a trial has happened, and they are harder to change than interim orders. Now, interim orders are temporary, typically made before any sort of trial has happened or a formal court proceeding. and they are easier to change than a final order. That doesn't mean that they're easy to change. They are just easier to change than a final order. So with a final order, in order to change a final order, typically you have to either appeal it or change it by agreement or ask the court for a different court order. And depending on what the type of order it is that is final, you're going to have to meet a certain legal test to demonstrate to the court why it should change. The typical legal test that the court will look at is whether it was an order that was intended to never be changed in the future. You could think of in Supreme Court, like the division of property. Typically, that's not something that you're going to revisit 10 years from now. But if it's parenting and it's 10 years from now, the child went from 3 to 13, there might be more of a reason for the court to change that final order. With the interim orders, typically those orders are made to help address an issue that can't wait until a trial. If any of you have ever been through the court process, you can know that sometimes it can take quite a while to get a trial date, especially if sometimes counsel is involved because we're working with so many different schedules. So the court will want to be able to put in certain types of orders until everything can be heard properly before them in a formal trial proceeding. In most cases, any type of order can be made final or interim, but there's typical ones that tend to be interim orders compared to final orders. And any order that is made on an interim basis can become a final order later. Or in some cases, they are replaced. So common interim orders would be what we call conduct orders, which are orders to manage someone's behaviors. That could include maybe how they speak to somebody, or whether they shouldn't talk to the children about certain subjects. It could be that the communication between you and the other person has to be in written form compared to, say, calling. Essentially anything to just manage the behavior. It can also be support orders. So child support, the court recognizes that you don't want to wait years on end to get child support. So there can be interim support orders made, and then parenting arrangements. The one thing for guardianship is that is something that is rarely a interim order, because you're either a guardian or you're not a guardian, but that doesn't mean it's impossible. But I wouldn't anticipate it. Okay, so how do you word court orders? I've included some resources that are just through the courthouse library and the provincial court themselves, because they have created a very nice pick list, which outlines a bunch of different types of orders, ranging from protection orders to child support to service deadlines. It's really handy. I myself use it often, and I do find when I'm in court, often the judges also have a copy with them. So then we can just simply refer to the code number beside it when we're discussing what types of orders to be made, rather than reading out every single word of the order. So it's something that I would recommend everyone go and look at. They do update it occasionally. The last update I've seen, I believe, was earlier this year. So you should check it occasionally, but in general, the overall wording doesn't change, and you don't have to worry about the codes that's for the judge's knowledge, but it'll help you figure out what kind of wording you are looking for. And it might even spark an idea as to what type of orders you want to ask for in your own applications. Because sometimes people won't think of other issues about children, such as travel or getting a passport, especially if you're dealing with someone who's not involved, like an involved parent. So the one kind of caveat I add to this is, even if the type of order that you're thinking of is not on either of these resources I've provided, that does not mean it's an order you cannot ask for. Rather, you're going to need to try and write out as best as you can as to what type of order you are looking for and why. And the judge can help you in most cases figure out what the proper wording is. And you can use these two resources as an idea or a starting point as to what, or like how to word your orders. A recent example I have is I had a client who wanted in a court order that if they were in a position to move closer to where the child was currently living, that their parenting time would change from them having one weekend a month to a week on, week off schedule, so shared parenting. That is not a common type of order, and it's also not something that was in the pick list, but it was still something that we were able to get an order of and find the proper wording. Even as counsel who practices in family law, it is quite common for judges to not like the way that we have worded an order, whether it be the language we've used or finding it too simple or too complicated. The simpler, the better in most cases. But if you're struggling with how to word an order, just talk to somebody else as well. Like if you didn't know anything about your case and you looked at that order, would you understand what it's supposed to mean? And that can be a lot of help to figure out what you're looking for. And then with these types of orders, obviously you can't make an order for absolutely anything. The idea of coming up with orders that might not be listed in that pick list is still within the same theme. For example, parenting. So maybe there's nothing in there about what parenting should look like, or you're not seeing any examples, you have a more unique situation, you can outline that. Worst case, the judge might tell you that what you're asking for isn't possible, but if you're able to explain what it is that you're trying to do, they might be able to help you figure out exactly what kind of wording would work. So with that, what types of forms would you use for the different types of orders? So I've listed out the typical forms used in family law matters. Each one might touch on various aspects of those different types of orders that I just went over, but the most common ones, I'm not sure if you can see my cursor, but the most common ones are Form 3 and Form 6. Excuse me, Form 3 is what starts an application and a provincial court family matter, and Form 6 is what you would use if you were served with Form 3. The other forms involve more particular issues, and I will go through each of these in a bit more detail here. So before you file an application about a family law matter, which is the first document to start any case in the provincial court of BC for family, is you want to first determine if this is the appropriate application. So this application is used to ask for orders where there is no current court orders or agreements relating to your family law matters. It can also be used to change or cancel any part or all of an existing order or family law matter, including any written agreement that you might have. The one important thing to remember with this is if you have a Supreme Court order, the provincial court's not going to be able to change or cancel that. So you want to make sure that the order that you're trying to change is provincial. So once you've determined if this is the proper application to use, then you want to determine what court registry you're going to use. So there are various different types of court registries, and which one it is will depend on which location you're going to. As of right now, the only early resolution registries are Surrey and Victoria, but it is anticipated that come next month, Port Coquitlam will be joining that list, and then later into next year, the other registries will be joining. So if you are not filing anything right now, I would suggest that before you do file anything, you check what type of court registry you are using, because if it is an early resolution one, you will have to go through those additional steps. The family justice registries are currently Kelowna and Nanaimo and the Robinson Square, Vancouver. And then all other registries are the parenting education program. So in order to determine which court registry you're going to use, it's not just simply going to be deciding if you prefer the early resolution or the parenting education program. You do have to file in a certain city, depending on particular circumstances. So if there is an existing provincial court file, you will need to file in the same provincial court that that file is in. So if you had a previous Surrey court matter, you'll need to file in Surrey. If you are starting a completely new claim and there's children involved, it needs to be the registry that is closest to where the child lives the majority of the time. So if you live in Chilliwack, you have to file in Chilliwack. You can't file in Abbotsford. And sorry if I mean if you and the child live there. If there's no children involved, then it would be the closest registry to where you live. So there are multiple ways to file an application about a family law matter, and a lot of this does also apply to all of the other court applications that you could file. But you can file it either in person by attending the court registry, by email, online, by fax, or by mail. I typically recommend in person for self-reps. So you're not having to deal with if something is not properly filled out, and having your court matter delayed because the registry will go over it right then and there before it is filed. Email is, I would say, the next best option. They are typically pretty quick, depending on which court registry you're using. If you are more north, I do find them to be a lot slower than like the Vancouver area. So just keep that in mind. If you do have something that's urgent and you can't attend in person because you're not close to that registry, there is fax options as well. And there is a new online form service. I'm just not very familiar with it. And I believe it's still in testing right now, but it would be on the provincial court website. Which options are available will depend by the court. Not every single court will necessarily have a staffed courthouse. So that is something that I would recommend you looking into. You can look at the provincial court website to tell you, or if you get too overwhelmed by that website because there is a lot of information on it, you can just Google the provincial court closest to you and try giving them a call to ask them how you could file your application. Now, once you've filed it, this is very particular to the application about family law matter, that once you have your filed copy of the application, you should receive a copy of instructions on how to fill out and file a reply, and you should also receive a blank reply. You will need to serve not only your filed document of the application about family law matter, but also that blank reply and the instructions on how to fill out that reply and file it. And if there's any other type of documents that you filed at the same time as your application, you will also need to include that when you're serving the other person. Common other documents would be a financial statement or a copy of the order that you're asking to change. So this is just an example of what a filed court document will look like. The most important thing is this stamp right here, if you can see my cursor. That just shows what date the court received the document. Here I just have Surrey, because that's the courthouse this was filed in. And this court file number will be blank when you file this first document because the court number hasn't been assigned yet. This is something that the court will fill in. If you have a previous court matter, you will want to know this court file number because that will have to be included on every document going forward. You won't have to worry about the family ID unless there has been one assigned to you, but that's not common. Now, for serving your application about family law matter, we went over some of the documents, but now how do you serve them? So with an application about family law matter, you have to personally serve this on the other person. That means physically handing them the documents to the other party. You can't simply just leave it on their car or email it to them. You have to personally serve them. And the person who serves them cannot be you. It just has to be someone who's over the age of 19, is not involved in the court proceedings, and whoever does do the serving for you will need to fill out a certificate of service, which is in Form 7, proving that service has been made. And that is the certificate that you will need to file with the courthouse as well to show the court that they have been served. So in case the other party and other person does not provide any sort of reply or participate in the court action, then you can keep going forward. So before we go on to the reply, I'm just going to pull up what the application about a family law matter looks like. So these forms are new as of, I believe it was August of this year. They're quite different than what's been in place for about a year or so. They have a lot of information on them, I find. So if you are able to read through it, I do find that there's a lot of really helpful information, but it does also mean that the document can be quite overwhelming because there's about 31 pages, but typically these applications on the long end are 10 pages. So many of these are not going to be something that you're going to have to file with the court, but it's here to help you figure out how to fill out this form. So these pages are just going over that. This is not part of your application. This is just to help you figure out what you need to fill out. I will just go to the actual application. So this is the essentially the first page of your application. This is where you put in the registry. You don't need to put in the court file number unless there is already one started and you're aware of it. And then this is where you would put the last name, so your last name and the other person's last name. Now, down here is just where you're going to kind of confirm that you need to give notice of this application, and it goes over kind of how to give notice. All of these forms are available online. I find the easiest way to find these documents is just by typing into Google search provincial court family forms. And it's typically the first one on the page, which should be by the provincial government. And they'll provide you all of the documents in PDF form. If you don't have PDF, then you will need to go to the courthouse to get copies of these documents to fill in. Because I find that unless you have PDF, they just won't download. So you just essentially need to go in and fill in all of these blanks that are required. If you're unsure of whether it applies to you, I would just recommend leaving it blank. In particular, when it comes to very specific details, like maybe you don't know their birthday, that's fine. Now, you don't have to fill out absolutely every single box in these forms. What you need to fill out is just dependent on what you're asking for. So if there's no children involved, obviously you don't need to fill out this. But you could have children, but they could not be involved in this particular court matter. So you don't need to outline just who your children are unless you are asking for orders about those children. This can be left blank. Now, some people get confused about this relationship. This is just asking essentially if you are their parent or not. You don't have to say like biologically, you can just say mother, father, because some of these forms are also used by grandparents. So they just want to get an understanding as to what your relationship is with that child. If there's any cultural, religious, spiritual upbringing, heritage that you think that the court should know about, you fill this out. This is especially more important for Indigenous communities because there are certain things that the court needs to be aware of when it comes to culture, because while we have obviously our legislation, what works for each family is again different. If this doesn't apply to you, that's fine, just leave it blank. But if it does apply to you, make sure to fill it out. Okay. So part 6 here, you'll see that this is just asking if there's any existing orders about these particular issues. So if there is, yes, you will want to click yes, and you need to provide a copy of that order when you file this. So it should be essentially the last pages of this application. If there isn't any, obviously it's no, it's fine. If you're unsure, I would put no, because if there is any sort of existing court order, either the other party is going to know about it or the court will learn about it through the court process. But if you do say no, and you are just completely unsure, you think maybe there is one, I would suggest bringing it up the first time that you're before a court, that you did say no, but you're unsure if there is one, and just ask to see if the court can help you figure out if there is an existing order or not, and then provide you a copy. You can also talk to the court registry, because as long as it is a provincial court file, the court registry should be able to help you and find copies. So part 7 here is where you're going to figure out which of the schedules of this application you're going to be filling out, because you don't need to fill out all of them. There's in total 11 schedules. You don't need to fill them all out. You might only have to fill out 2, depending on the type of orders you're asking for. So each of these are the types of orders that I'd gone over: parenting arrangements, child support, contact, guardianship, spousal, and division. So um, if you are, say, going for parental or parenting arrangements and there isn't any previous order or written agreement on that issue, you would say no and you'd fill out Schedule 1. If there is an existing order or agreement, then you would fill out Schedule 2. And the same applies for all the other schedules going forward. The only one is guardianship. That one doesn't matter if there is a final order or not, with respect to the schedule at least. So part 8 is just helping you figure out if you are filing in the proper registry. This is part 9. You'd only fill this out if you have a lawyer. If you do have a lawyer, they would most likely be the one doing this application for you. So I, in general, would just be leaving it blank, because if you get a lawyer later on, or if you're in a period where you're thinking of retaining a lawyer and you haven't yet, that lawyer can easily just go ahead and go on court record later. So I just leave that blank unless you do for sure have a lawyer who is going to be involved in this court process. Now, your address of service, this is where you're going to get all of your court documents. It is really important that you put in an address here where you will get mail. And I would also recommend putting an email, because that is the easier way to get documents from the court. It's a lot faster than mail, because the court will provide you copies of filed copies of everything. And this is especially important if you are not attending in person, because this is the only way you're going to get the filed copies of anything. So for schedules, I'm just going to go over the parenting arrangements one. So in this one, we're assuming that there's absolutely no court order or written agreement involving parenting arrangements. So in this, I need to put in whether I am the guardian or if I'm applying to be appointed as a guardian. So for this one, I'm just going to say I am a guardian. I'm pretty confident that I will be found as a guardian of this child. So here's where I'm going to put in what orders I want for parenting responsibilities. So if you remember back in the slides, that's section 41 of the Family Law Act, which included things like decisions about medical procedures for the child, or religious upbringing, education. So this is where you'd want to outline what you're looking for. There are some parents who maybe they feel that they are better equipped to make medical decisions for the child, but they're okay to share all of the other decisions with the other parent. This is where you would outline that. So you don't have to put in extreme detail, because you can see that there's not a whole lot of room in this document. But if you know that you want all of those decisions to be on you, then this is where you would put that in. So a good example would be oh, if I could spell, there you go. So you don't have to put in a whole lot of information. You can just say, I want full parental responsibilities. Or you can say, I want to share parental responsibilities with the other parent. And for parenting time, this is where you'd outline what you want in parenting. If you have maybe a more complicated schedule, try to explain it as much as possible. but it can also be in more simple terms because maybe you want shared, but you don't know if you want week on, week off, or a 2255 schedule. You can put in, I want shared parenting. And you can leave the discussions as to what exactly that would look like to before the judge or with the other party as you move forward. So, you know, these last two are more kind of like specific as to whether there's any other conditions you want included when it comes to these parenting responsibilities or parenting time. So, for example, let's say you put up here shared parenting responsibilities. Down here, you can say, I want shared, but I want to have the ability to make a final decision if we can't come to an agreement on maybe the medical issues, or I want what we call first right of refusal for parenting time, which is where maybe one parent is unable to care for a child for, let's say, 48 hours before just getting another family member or a babysitter to care for that child. The other parent wants to be contacted to see if they can take the child for that 48 hours. That's where you would be putting in conditions that you're looking for. And a lot of those are shown in the pick list for ideas. So number 5 here, it's kind of ties into for, I will say, like, I'm not a huge fan of the new orders. If anything, I find that they've made it a bit more complicated for self-representatives by making it so specific. But these directions are just if there's any kind of other conditions that you think would be important to put on parenting. Common ones would be if maybe one of the parents has drug or alcohol issues, asking that the court put on conditions that the parent is not supposed to drink any alcohol 48 hours before they have parenting time with the other parent. Those are just kind of other directions. So you can be as detailed as you want or as you can fit into these blanks. But if you're unsure of what kind of directions you're looking for, I would suggest looking at the pick list to give you ideas. But if you still aren't sure, it can still be something that you bring up later. But instead, you could just maybe outline some of the concerns that you have and then try to figure out what exactly the court order is that you want. Now, number 3 is where you're going to have to outline why you're asking for all of these orders. You're not going to have to present your whole case in here. It's just your belief as to why you think these orders that you're asking for are in the child's best interest, because that's the legal test. What's in the best interest of the child, not what you want, not what your partner wants. What is best for this child? So maybe you both want 50-50 parenting, but is that what's best in the child's interests? Is it going to involve too much travel for them? So I will go over that a bit more in my presentation, as well as to kind of what the best interests of the children are. But in general, looking at Section 37 of the Family Law Act, which is in decent, simple language, outlines what the court would be looking at for determining what's in the best interest of the children. So for Schedule 2, this is what you'd fill out if there's a current order. So you'll see it asks if there's a final order or a written agreement, and you would just put in which one that is, and then the date that it was made, and then provide a copy. And then kind of very similar to the earlier schedule, you're going to be asking what you're looking for to change, but they're going to want to know what's changed since that agreement or court order has been made. Maybe it's that you two agreed to shared parenting, but the other parent's not following that anymore. Or maybe one of you has moved farther away and it's too much travel to and from the school that the child's currently going to. This is where you would outline what's changed since either that agreement or court order was made. And then you're going to be outlining if you want to just change a term. Maybe there's only one part of it you dislike. You want to, or you want to cancel it. Quite frankly, I see suspend and canceled as the same thing. So I think this is redundant, but canceled or changed. Now for the written agreement, it's a bit different of how the court looks at it, which is why it asks why you think it's no longer in the best interest of the children. The reason why it's not in the best interest of the children could be the same reason as to why the needs have changed. Maybe one of you has moved farther away, so it's no longer in the best interest of the children to have to travel that distance between you and your partner, your ex-partner. And here you're just going to be outlining if you want to set aside or replace it. Part 4 is where you're going to be outlining what it is that you're looking to change or replace that current agreement or court order with. So that'll be very similar to the earlier ones where you're outlining the parenting time or parental responsibilities. And then you'll also have to explain why it's in the best interest of the children. I am just going to go down to Schedule 7 here, which is the guardianship. So if you are applying to be a guardian, this is what you would use. And then if you're also looking to remove someone's guardianship, this is the same schedule that you would use. So you could be looking to remove someone's guardianship, whether they have guardianship by court order or just the same reasons as to why you're a guardian, that you meet the definition of it. And this is the schedule that you would use. So if you are asking for the parental responsibilities, etc., but you're unsure if you're a guardian, you'd fill out both Schedule 1 and 7. And you're going to be asking to be appointed as a guardian, and then outlining why you think it's in the best interest of the children. And then there is also a portion here for Indigenous ancestry of the children, and you can be as detailed as you want there. Now, with a guardianship application, there is going to be specific documents that you need to provide with, for it. So Part 4 here outlines what those documents are and sort of how to find them. A guardianship affidavit would also be available online at the same place where this application is on the provincial court website. Okay. I am going to go back to the presentation here so I can make sure we have time for everything.
Hi, Catherine. Sorry to interrupt.
Yes.
Yes, if you want to double check your slides, and also if you would like to take like a 5-minute break. I don't know if it's you want to just continue, but we could take a 5-minute break if you need one.
I mean, I'm okay, but if other people would like to a quick break,
It's usually
because I know I have a lot of information.
Yeah, I usually just offer the presenter a quick break because it's a lot of talking for them, so I just don't want it to be too much. But yes, if you're good to go, then we'll just keep going, okay? Thank you.
Okay. Perfect. Okay. So, okay. So, now, if you are served with the application about a family law matter, now I'm going to go over the document that you would fill out if you were served with that, which is called the reply and counterclaim to an application about a family law matter. So this is an application that involves two portions. You might not be filling out both portions. If you are served with an application, you will for sure be filling out the reply portion, but the counterclaim portion might not apply to you. So the reply portion is used to agree or disagree with the orders that are being asked for in the application about family law matter. And then if you disagree with them, if you don't agree to the entirety of what the other person's asking for, my suggestion would be disagree, because you don't want the court to think that you're okay with all of the wording as to what the other person's looking for. You can disagree to a part of it, and that's something that you can explain in your reply, what specifically you disagree with. Now, the counterclaim portion, this is where a lot of people get very confused, because even lawyers, I find, get confused with it, because it is a newer process compared to how our provincial court system has worked for many years, which is if somebody, for example, has asked for orders about child support, but you disagree with all of the types of orders that they've asked for, but you still want to seek child support, you wouldn't fill out the counterclaim portion. That is not typical in our practice. If we're in Supreme Court, we would be filing a counterclaim, but in provincial court, if they have filled out a schedule on child support, you would not be asking for child support in a counterclaim. You would only be responding to the child support. But if, let's say, for example, they filed the claim and they didn't touch on child support at all, there's no schedules for it, then you would file the counterclaim to ask for child support. So a reply, the reply portion of the document is schedules 1 to 6, and then the counterclaim are schedules 7 to 17. And you'll only fill out the schedules that apply. And the same applies for the application about a family law matter. So before you file your reply or counterclaim, you'll want to see what court registry that the application about a family law matter was filed in, because that is determining what registry you need to file your reply and counterclaim in. You'll also want to figure out how much time you have to file your reply and counterclaim, because you have 30 days from the date that you were served, not from the date stamped on the actual application. For example, if the application was filed October 10th, but you didn't receive it until October 20th, the 30 days start from when you were served on the October 20th, not October 10th. It is very important to understand when the 30 days are, because the court registry can deny the filing of your reply or counterclaim if you are outside of those 30 days and the other person has filed that certificate of service proving that you were served 30 days ago. There are some court registries who will allow it after the 30 days, but I wouldn't chance it, because after those 30 days, you are going to need essentially a court order allowing you to file that reply, which can be sometimes annoying and difficult to obtain if you're already worried about whether the other person's continuing the court process without your knowledge. The court registry might be a bit more sympathetic with you because you are self-represented, but it is something that I would be very mindful of just so you can avoid that headache. So when you do file your reply and counterclaim, the other party does also need to be served with a copy of it, but it's a bit more unique where you don't have to personally serve the other party, and the provincial court will provide a copy to the other person on your behalf to the address of service that they have provided to the court when they filed their application. But I would still recommend, if you have a mailing address or email, to still send it to the other person when you receive your filed copy, just to avoid the other party arguing before the court that they didn't receive a copy. Because I have had instances where the registry may have sent it to the wrong address, or for some reason it got missed. So this just kind of covers your bases to avoid wasting court time arguing over whether someone's received something or not. So I'm now going to go into a bit more of the particular applications that you can ask for in provincial court. But I will, just before I move on to those, I will just show what the reply and counterclaim look like. All right, so this is the, it only says reply, but this is the reply and counterclaim. It's very similar to the application about family law matter, where there is a lot of detail. It does kind of help you walk through what schedules you need to fill out, such as this kind of handy box here. But this would be the first page. This is where you would check off if you're filing a counterclaim with your reply. And then same thing with the registry court file number. So this is where you'd fill out all of the information, very similar to the application about a family law matter. But what is more important is which schedules you're going to be filling out. So here, fortunately, these new forms do at least show you that you can outline what's not applicable or not, to kind of help you figure out whether you are filing like a counter application or not. So parenting arrangements. So here you agree with the request or you disagree with the request. And then if you're making a counterclaim, which schedule you'd be filling out. The same would apply for all the other types of court orders. You'd essentially go through each of these and figure out if it's not applicable, if you agree, disagree, or if you're making a counter application to figure out which schedules you're filling out. So first, parenting arrangements. Let's say the other person was asking for them to have primary, so the majority of the parenting time, then this is where you would fill out why you disagree. So you could say, like, I disagree, it should be shared parenting because the child has a good relationship with both of us, and we're able to facilitate it. That's a very basic way to outline it, but that is a way that you can outline it to the court. Just essentially outlining why you agree or disagree and asking for essentially what you're looking for. So number 3 here, though, is where you would give your more specifics as to exactly what you're looking for. So up here, you could say like, I disagree because I'm seeking shared parenting time for whatever reasons. And then here you can outline, I'm looking for shared parenting. If you have a schedule in mind, you can outline it there. You can outline what your parental responsibilities that you would like. And how much you provide in your reasons to disagree, I would say kind of depend on how specific you want to be about the orders that you're asking for, because then it's better to save it here and just outline why you disagree with something. I find in a lot of cases that the reason why you disagree with something can sometimes just tie to what you're asking for. So if you're not able to separate that's okay. The court will be fine with it. Lawyers will be able to understand it. You're not going to be penalized for it. But if there's a lot of reasons why you disagree to what the other person's asking for, then just save your comments that have to do with what you're specifically asking for in number 3 here. Part 4, again, that's where you're going to be just outlining why what you're asking for is in the best interest of the child. This is not where you're going to be outlining why the other person's not in the best interest, like what they're asking for is not in the best interest of the child. It's why what you're asking for is in the best interest. Okay. So I'm not going to go through the schedules in great detail just because I want to make sure we do get through everything and have enough time for questions here. Okay, so now an application about enforcement. This is the application that you would use if you want to enforce something like a court order or written agreement that's already in place. So the application about a family law matter, if you want to change a previous court order or agreement, that's the application you would use. But if the court order that you have, you want to enforce, it's an application about enforcement. You don't need to go through the whole process of filling out that larger document. This is the same application that you would use if you're asking for consequences to happen to the person who is not following a court order or a written agreement, such as maybe a fine or a conditional term. This is the same application that you would use to set aside a registration of a foreign order, but that only applies if you've been served with a notice of registration of said foreign order. The next application is the one that I find most people get confused with, which is the application about a priority parenting matter. Because I mean, no fault to the parents, but anything with your children can obviously seem like a priority, but on the legal side, whether it is actually a priority varies. So the application about a priority parenting matter is not meant to be used if you're asking to change what the parenting time looks like. That is an application about family law matter. This application has a defined list of what time sensitive issues are. So even though it's a priority to you, it doesn't mean it's a priority to the court. So the priority parenting matters are typically about decisions for a child where the guardians are not in agreement and it's something that needs to be decided soon. So in most cases, this often involves medical procedures, but it's not something like, say, if you want to change the religion that a child is being raised in, or even some cases, the schooling. Sometimes the schooling can be considered priority if you're looking at a very short deadline. But the court's going to also want you to start your court applications, say, well before August, if you're looking to deal with something in that same year in September about a child's school, unless it was maybe something that you couldn't have foreseen. So this is intended to be something that's very urgent. I will still say that even with priority parenting matters, it can still be a slower court process. So depending on the particular issue, if it's something that you can see coming up, like let's say parenting time for Christmas, that is a very common issue to come up. It is better to start planning for that well in advance, because one, the court might not see it as a priority, or two, even if the court agrees it's a priority, it might still be difficult to get a court date in a reasonable time to address that issue. So under the provincial court family rules, it outlines what a priority parenting matter is. This slide just outlines what the court considers a priority. So you can see the first one: giving, refusing, or withdrawing consent to medical, dental, or other health-related treatments for a child if delay will result in risk to the child's health. So this last portion is what's important. If it's not like, if it's, for example, maybe braces and it's more of a cosmetic thing, it's unlikely that the court's going to find that a priority matter, and they'll want it to go through the traditional sense of the application about a family law matter. Other examples are applying for a passport. Again, if that delay will result in harm to the child's physical, psychological, or emotional safety, security, or if you've been trying to travel with a child for some time and the other side's just being unreasonable, this is also an application that you could use for what you believe is wrongfully denied travel. This application can also be used if one of the parents is saying that they're going to be moving with the child, but that will only apply if there's nothing currently in place for parenting arrangements. If you currently have a court order or a written agreement about parenting arrangements, this is not the application you can use for that relocation issue. It's a separate application. Excuse me. You'll also see that this is where like the Hague Convention is mentioned. So essentially just read through all of those to see if it's something that it would apply. I've seen some cases where the court will still allow maybe that application to go forward, even if it doesn't necessarily hit the definition, but it is a risk because it will very much come down to essentially the sympathy of the judge at that time. So I would recommend trying to make sure that you are filling out the correct application, because it can add delay if the court disagrees that this is something that's a priority, because then you're starting from scratch now and having to file the traditional application, which has certain service requirements and response deadlines that are a lot longer than these other applications. The next one is an application about a protection order. This application is more unique compared to the others, where it's one where the registry doesn't matter. You can file this in any court registry, regardless of whether there is a current matter going on, where the children live, where you live, etc. This is considered a priority to the court, so you can file it anywhere. If you're able to, I mean, I still usually recommend trying to file in the registry that it would follow going forward, but it is meant to be not restrictive due to the nature of the order itself. So this application can be used to ask for a protection order to protect you, your children, or another adult, which are typically other adults that may live with you or the child. This application can also be used if you were served with a protection order, where you can ask for the court to change terms to it or cancel it outright. This application can also be made with notice or without notice. It is up to the judge as to whether they feel that you've met the test for it to be without notice. But if it is without notice, or if it is with notice, it is a shorter turnaround time. You're not waiting 30 days for a reply. It is 7 days. With these protection orders, any order that is made, unless the court says otherwise, typically expire within a year of when the order was made. This is a less used application, which is the application for a family law matter consent order. This is the application you would use if you and the other party have come to an agreement and you want it into a court form. Because you're not represented by lawyers, this form can be very helpful, even to help you outline as to what you're looking for, because it is quite detailed. If there is any sort of chance of agreement. However, I still usually recommend that even if you two do come to an agreement, that you attend court to actually talk to the court about what you've agreed to ensure that the orders make sense, and you're not dealing with the possibility that once a judge does review this application, that they just deny it because they have concerns as to what you've agreed to. Because if you're before a court, you can at least explain why you've come to these agreements, and then the judge might more agree with you. Because I've found that even as counsel, these documents, this particular application can sometimes be difficult to explain to a judge as to why certain orders should be made, because it's limited in the amount of space to explain your case. But if you're looking for more simple orders and you're not doing anything kind of out of the ordinary of the pick list, this can be an application that can be very useful if you and the other party have come to an agreement and you just want to make sure it's in a court order. The application about an order prohibiting the relocation of the child. This is the application you would use if there has been a written agreement or a court order about the parenting arrangements of a child. If there hasn't been, then it would be the application about a priority parenting matter. The next two applications I'm going to go over are essentially the same, except one is with notice and the other one is without notice. So an application about a case management order is designed to ask for orders that are procedural and administrative, which essentially means how your case is going to proceed. This is the typical application that's used for really anything that doesn't fall under all of the other applications. Unless it's like very specific to like a parenting issue. So examples of case management orders would be if you want to change the court registry, maybe the previous court applications have been in Surrey, but neither you or the other party live there, and now you're both in Chilliwack. Doesn't make sense for both of you to have to continue to go to Surrey. This is the application you would use. It can also be used to schedule a court appearance if it was canceled, or if you need to reschedule a court appearance because it doesn't work for you and the other person. This is the same this is the application you'd use if maybe you're having difficulty serving the other person because maybe they're evading service, or maybe you don't know where they live anymore. It can be for whatever reason. This is where you can ask the court for what we call substitutional service, which is just essentially orders allowing you to serve the other person in another way. This is where you can also ask for those conduct orders. So rather than maybe having to go through the slower process of the application about a family law matter, there's something that would be very beneficial to the case right now, such as maybe limiting the communications between you and the other person. This is an application you can use. There are many different types of examples that the court explicitly outlines for this type of application that you can find on the actual application sheet, or listed at Rule 62 of the Provincial Court Family Rules. Now, for an application without notice, this one is more restrictive because not everything not every single order that you could ask for under the case management order with notice is appropriate to be made without notice or attendance. Without notice or attendance is typically for orders that have to do with service or requirements, because obviously if you're asking to serve someone in a different way, it's because you can't get a hold of them. So it makes sense to force you to try and serve that application on them. Or this can also be used if maybe you want to attend court virtually, but they've ordered it that you have to attend in person. This is the same application you can use. Other examples are also outlined on the application itself through the provincial court, or at Rule 65 of the Provincial Court Family Rules. Now, what do you need for your application? As I said earlier, it does very much depend on what types of orders you're asking for. So unfortunately, I'm not going to be able to go through each and every application in detail of what types of documents might be typical. But in general, in family law, the majority of the evidence provided are your words and the other party's words. So that would be your testimony, whether it be spoken word or written form. In written form, it would be the form of an affidavit, which is a sworn or affirmed written testimony. The one important thing to know that if you want to file affidavits with the court is that in provincial court, they are limited to 25 pages total, and they do not want you to provide evidence on a USB stick. There also should be absolutely no intimate images of any person, which they define as any sort of nudity or explicit sexual activity. Also, I would, in general, just think twice before you include photos of children. unless it is absolutely necessary for the judge to make a determination on the orders that you're seeking. The judges don't need to see pictures of you and the child smiling to understand that maybe you have a good relationship. That's not necessarily something that is required. And while family matters are not a public record, they are still on court record. So any sort of photos that you are filing is going to be on that court record. So just think twice before just sending in a bunch of photos of your children. So some typical documents in family law matters are information on your income. This would apply for the child and spousal support. The typical ones that they want is your income tax returns and your notice of assessments or T4s. If there's any sort of previous court order or written agreements, the court will want copies of those. And then any communications between you and the other person that might relate to the orders that you're seeking. For example, if you're seeking a protection order, it could be messages showing the other party threatening you or your child. When you're thinking of the certain types of documents, just think of how it helps demonstrate to the court maybe your written or spoken testimony. It's more to kind of bolster it, but in general, the majority of the evidence is going to be your word and the other person's word. So I'm just going to go through some general tips when you're seeking court orders. So the first one is focus on the future. Think about what you want for you and your family going forward, rather than trying to fix what might have happened in the past. You can't change the past, but you can change the future. So what do you want it to look like, and what kind of orders do you think would help you get there? For example, maybe right now shared parenting time doesn't work for you, but maybe it might in the future because you're anticipating a job change that it's going to be much more flexible. So maybe the types of orders you want is figuring out what your current parenting time would look like, but then you want to be able to review it, let's say in a year from now when you know you're going to be starting a new job. Next one is when it comes to any sort of orders on children, the only thing you should be thinking about is the best interests of the children. Your previous partner may have been a terrible partner, but that doesn't necessarily mean that they're going to be a terrible parent. Being a parent means putting your child's interests first and their needs first. And that extends to when you're having to work with your previous partner. Not every couple is going to be able to seamlessly co-parent. There's no expectation that you're going to have to be friends. But so think of what kind of orders would be helpful to help you and the other party co-parent. Is it conduct orders? Maybe the other person has a hard time speaking in a positive manner to you. So maybe a court order requiring them to. Or is it having a defined exchange location? So you're avoiding arguments as to who's picking up the child and where. Manage your emotions. Family law is obviously very emotional. No one's expecting you to be emotionless, but your emotions shouldn't drive the types of orders that you're wanting. The main difficulty I find in my career is managing my clients' emotions and trying to get them to separate that from kind of the bigger picture and the court orders that they're asking for. So I personally obviously have no skin in the game, which is why I'm able to look at it in a more neutral way. Because I don't have to deal with this person outside of the court matter. I'm not going to have to deal with them for 18 years with a child. So my job is to make sure that my clients can focus on their goals in the future and what types of orders would help them get there. It's also very important that your emotions don't take over your speaking in court, because while no one is expecting you to have to like hold back tears if you're dealing with something very emotional, and you're going to feel angry at times. But you don't want that anger to take over why you want a certain type of court order. The court orders are not meant to be revengeful. They're not meant to take it out on anybody. It's not going to help you. What's going to help you is figuring out what types of court orders are going to help manage those emotions going forward. Overall, seeking revenge is not going to work out well in the court. You might have a few wins here and there, but that doesn't mean it's going to continue feeling like you're winning later on. Because even if you are successful at getting some sort of revenge order against the other party, if it has to do with children and you're just restricting the other person's ability to be in that child's life just as revenge, the child might not be aware of that at that time, but it is something that they could become aware of later. So you might not see the consequences for years later, but something to think of, which is why I say look at the future. What is it that you want for the future? How do you see you working with the other party going forward? What do you need to do that? The next one is to be concise. The court is quite busy. Judges want things in and out as efficiently as possible. So when you're explaining your case, you need to focus on what's most important. For example, the court doesn't need to know why you and your ex-partner are no longer together, but the date that you two separated is relevant. The judge does not need to know your full story, but they do need to have an understanding as to why you're looking for certain orders, but you don't need to go into great detail. When I meet with clients for the first time, I find a lot of them want to give me a huge backstory as to why they believe someone's going to be difficult to work with because maybe 5 years ago they wouldn't agree to XYZ. That's not something that the court needs to know or I need to know. What's more recent? Why is it that you feel this order is necessary now? The court doesn't care what happened 10 years ago unless it relates to exactly what's happening right now. Because maybe I was a very difficult person 10 years ago, but that doesn't mean I am now. So what's more recent? What can you show the court as to why you need that particular order now? Some other general court tips, which apply not even specifically for your orders that you're seeking, but just in general, is at no point do you want to be blaming, criticizing, or calling the other person names in court or your applications. You can be critical, but there's a difference between criticizing and blaming. You can question whether someone's decision was in the best interest of the child, but saying something like they're a terrible mother because they did X, Y, Z, that's not going to help you. Instead, you can say, I have concerns about the parenting time that the other party wants because of XYZ. You don't need to make it personal. Never yell or cut off the judge or the other party. Wait until it's your time to speak. This can be very difficult if the other person is saying a lot of things that you feel are untruthful, or they're the one blaming and criticizing you, but you do not want to cut them off. You will get a chance to speak. And if you aren't sure if it's a good time for you to speak, because maybe there is just a quiet period, just ask the judge if you can reply. They'll let you know when you're able to reply. And as I've kind of mentioned many times throughout this, if you're seeking any types of orders about the children, review Section 37 of the Family Law Act and think about how the orders relate to those best interests that are listed. And then if you are going to provide any sort of written communications between you and the other party, don't only provide like a particular screenshot of it. If there's other parts of that conversation, even if you don't think the rest of the conversation is necessarily positive for you, if you're only providing half of the conversation, the court might have concerns as to whether you're being fully truthful. The court doesn't expect you to be a perfect person, but they do expect you to be truthful and own up to any mistakes that you have made. And that kind of goes into the last point. Always be truthful. Don't provide half truths, especially important if you are seeking anything without notice. Because if it's found out that you were not providing the full story, or you were only, or if you're twisting how the story played out in a without notice order, that order can be canceled and the court can see you in a negative light going forward. These last slides I'm not going to go through in great detail, just because they are more an outline of just the resources, and my understanding this will be provided to you. So these are, this first link is just where you can find those family forms that I've mentioned. And then this is the online Family Act Assistant. Essentially, it is sort of similar to just downloading the forms, but it's a bit more interactive where it kind of helps fill out the forms for you. And then in general, I find Legal Aid BC does have some pretty good guidebooks and legal information there that can be very helpful. So I'd suggest taking a look there. And then for some free and low fee legal advice resources, there are multiple. You might not qualify for all of them, but it's something that is worth to look into. The one thing for any of these resources I am showing going forward is they don't provide full legal representation. So they're not going to represent you from the start of your case to the end of the case. So this is more just to provide you help at that certain time or with a particular issue. Some other resources, there's the Family Law Line, and then legal coaching, which is something that I currently offer, but there's also a bunch of paralegals who also offer it, and lawyers. The affordability of it very much depends on who you're using for legal coaching, but as well as how much legal coaching you need, because it can easily add up. But it is something that might be worth looking into, because I do know, since there are a lot of paralegals who also offer it, their rates are much lower than lawyers. And then the lawyers who only offer legal coaching also tend to have more reasonable rates as well. You can find a list of registered legal coaching at Legal Coaches Association. And legal coaching can be for more than family law as well. Okay, now with that, we can get into the questions.
Perfect. Thank you so much for the presentation. I can definitely say for myself, at least, that was very informational, and we greatly appreciate everything that you went through with us. So there's a couple questions in the chat. just for some of the questions I'm just seeing, there are number ones about case specific questions. So again, if we don't go through your specific questions tonight, please just send it to our email address, info@litigantschoolbc.com. So just yeah, if we don't go through it, then it's just because either we didn't have time or we're not able to over the Zoom session. So some of them, can interim orders impact the decision making for final orders? Example, create a new precedence for, like, I guess the case.
Yes, the short answer to that is yes. There are definitely times where the court will see an interim order and rely on it when they're making their final order, but there are other times that they won't. It is very dependent. What more helps somebody essentially argue that that precedent shouldn't apply when the judge is looking at making a final order is if it has the terms without prejudice, which the courts do typically assume that most interim orders are without prejudice, but I have found that judges don't always. So if you're able to get the terms without prejudice, that can typically help prevent essentially a precedent being made.
Okay. Can you request an extension of service before serving for a reason of like being sick or other reasons?
Yeah, you can definitely ask for an extension of service. Whether it depends on what exactly you're serving as to whether that's needed. If you're the one who started an application in the provincial court, you don't have a deadline as to when it has to be served, except for maybe like a year or so to make sure that it's still an active case. So if you're the one who needs to serve a starting application, you can kind of serve it whenever. I don't necessarily recommend waiting just because the other person could start their own application. But if you're the one who is serving maybe a response to something and you need more time, that's where you would use the case management order to ask for an extension outside of the court rules.
So this is just a question about you mentioned that if judgment has been made by a superior court, then provincial court cannot make changes. If judgments are from superior court outside of BC or other province, is it necessary to file all documents and forms through the superior court?
Sorry, I'm just finding that question too.
No worries.
So
Yeah, it's just scrolling down from the top. Yeah, it's a little bit long. It's 6:28 p.m. if that helps.
so if I understand it correctly, so if you have court orders from a superior court, then you would need to proceed through superior court. And whether you need to provide all documents and forms from that other superior court would depend on what the particular issues are. Like if you're looking for parenting orders in BC and you have a court order from Ontario that has to do with parenting, yes, that would be relevant to the BC Superior Court. But if the other order has to do with property and you're seeking parenting, that's not relevant. So it'll more matter what particular orders you're asking for in each court. And then the same applies for in provincial court too. If you have a superior court order about parenting time, you should be applying in superior court, but depending on the particular order you're asking for, it might or might not apply in provincial court. And then just providing a copy of that superior court order can be helpful to the court to determine if it applies or not. But it should be around the same subject.
Question about setting aside versus replacing an order. It's the difference between the two phrases, I guess.
Okay. So typically when you're replacing an order, you're usually not replacing all of it. Whereas when you're setting it aside, you're typically putting aside the entire order. Typically, when you're putting aside an order, it's something that might be harmful to like another type of court order. Like a typical one is if there was an order of protection made against you, it is better to have that set aside because then it's like it never existed on the court record compared to if you're just changing something in it because then it's still on court record. The idea is to remove it from court record.
Okay, perfect. So people are asking for a draft of the filed application or reply application. So in our materials, we will send out a copy, and I think it's at the end of the slides as well. It's just a link to all of the provincial court forms. A sample filled out one is a little difficult due to confidentiality. We'd have to kind of make like a full fake one. So
Mhm.
I can check with our team about that, but we don't have anything on hand for sending out for materials. But that's just something I will note down, and I'll talk with our team about that just for everybody. Do just reading through some of the questions. Um, There's a couple questions, or there's a question about an affidavit and the form of an affidavit. We do have a session on preparing financial statements and affidavits. So we'll go through evidence and affidavits in that session. Okay, I don't see any other questions right now that are not case specific. So does anybody else have any other questions that they'd like to send in to Catherine? Um, just a quick note, there is a quick question about using like Family Wizard to serve another party. And Catherine did mention about substitute service. So unless like they would need to seek an order for substitute service to be able to do service on some other kind of method. So unless it's in their address for service, like an email or a home address, those are the mainly the accepted forms of service. And if you need to serve them in any other means, you need to do an application to obtain an order for substitute service. I personally haven't seen anything for our Family Wizard, but people have used Facebook, they've used, newspaper, those kind of other services as well. Catherine, have you ever seen anybody use the Our Family Wizard app for serving?
I haven't seen our family wizard, but I think kind of like the concern for that would be it might be seen as the party is serving them when if you're trying to do personal service, um, depending the court, like your substitutional service, if it allows you to do the service, then that should be fine. But even typically when you're serving through email or Facebook, they'll still want it to be somebody who's not the party serving it.
Okay, great. And just, yeah, if you don't know where the party is and you're trying to serve them, I just mentioned in the chat, you will have to
Mhm.
try to find them. So there's services like skip tracing and private investigators. If they're not able to locate them, there's other methods of just putting it in a newspaper in the area that you think they're at, but that's a little more complicated. So but generally just look for a skip tracer or private investigator first. So we are up at our time here. So if there are any questions that you guys didn't get answered, um, we'll have to put them in our email. So just info at litigantschoolbc.com. A couple of questions coming in last minute. We are out of time tonight, so just send it by email. Thank you, Catherine, for coming and joining us tonight. We really appreciate your time, and we'll see everybody next week for October 29th for week 4. Have a good evening, everybody.
Thank you.
Yeah.
Bye.